I wanted to start with some context on why we're here. According to Surrey Associates, that's a market intelligence firm based in the US, 84 trillion US dollars, that's about 260,000 US per person in the US, of wealth will be transferred between now and 2045. According to the firm, that's actually the largest wealth transfer in history. So in that context, we can assume that estate planning has really never been more relevant or important. I also, at this point, just want to, before we start, acknowledge our director, Robert Taylor. This event was actually his idea many years ago. So thank you, Robert. One of the things I think that Robert had noticed, as well as we did in our business, was that, well, we both witnessed the transition of wealth in the lines of business that we are in. And it seems that no matter how clear-cut the legal documents or how well-established the instructions, you can encounter really difficult and nuanced challenges or issues and questions. And in fact, Levy Cheeks has helped us navigate some of our own liability and issues in these precarious situations. It seems that no matter how large or small an estate is, or clear or ambiguous the documents are, there's somehow always nuances or curveballs once siblings or money are involved. So these are the realities that brought us here today, and we're very excited to walk through some of these issues with you. I'll just give everybody a quick overview of what the program will look like. We'll start off with a 40-minute presentation from Bruce Levy of Levy Cheeks, who will tell us how we can leave behind a legacy and not a treasure hunt. And you'll also have the opportunity to ask him a few questions after. After Bruce's Q&A, Tony Ann will take 20 minutes to tell us how to ensure that your estate actually continues to grow and remain safe and liquid for your next generation. You'll also have the opportunity to ask her a few questions after her presentation. So thanks, everybody. Without any further ado, allow me to introduce our first speaker. Mr. Bruce Levy is a founding partner at Levy Cheeks. He has been admitted to practice in England and Wales, New York, and Jamaica. He practiced in London for 13 years before returning home. He holds an LLB from London School of Economics and LLM in Corporate and Commercial Law from the University of London. And he's also advised on some of the largest transactions in the country in both the private and public sector. He's advised on the merger and restructuring of some of Jamaica's largest family-owned businesses, so we can assume that he's no stranger to family politics. Bruce also has experience in complex commercial dispute resolution, with particular experience in the field of shareholder and joint venture disputes. As you can see, Bruce excels in complicated matters, which is why he also has a golf handicap of 6. For the non-golfers in the room, that's really very, very good. So please join me in welcoming Bruce to the podium.
All right, just checking works. All right, welcome everyone. Before we start, a few quick thank yous. Well, first of all, thank you all for coming. Thank you to the Sterling team, Marion, Tony Ann, and everyone else. Thank you to the Pegasus team for putting this together. Coffee was very good. I noticed a few lawyers out there, Robert and others. Thank you for not asking too many complicated questions. In all seriousness, this is somewhat of an interactive process, so please feel free to chime in, and there may be some issues which come up which you may be better poised to respond to. For instance, my expertise or my experience tends to be more in estate planning before the inevitable. There's a process that comes afterwards, which is the whole probating process, which I have a little bit less experience dealing with. My partner, Stacy, Ann, handles probate for our firm, but I think there are a few others that do. So if anybody has questions relating to that process, you may be called upon to assist. All right. I've been asked to address you on what we lawyers call estate planning, which is just a fancy way to say putting your affairs in order. What we mean by this is identifying and understanding the steps that we all need to take to ensure that on our death, the assets of our estate are distributed in accordance with our wishes and with a minimum of fuss and delay. Of course, the good news is that you will not be around to deal with the consequences of failing to do so. The even better news is that you will not be able to blame your lawyers. Okay, the objective of today's presentation is to give a flavor of the considerations, both legal and practical, that go into an estate planning process. I'm also going to add two topics which I thought of on the way driving here, which were not initially in my presentation. I'm going to start in the reverse. I'm going to start by giving a real-life example. Now you know how complicated estate planning is. A real-life example, which actually is based on a situation that I encountered a few years ago, not specifically, but you'll get the gist. So here's the situation. Someone called John. He's 80 years old. His wife has passed. He has 3 children, Anna, Bruce, and Charles. Anna works as a part-time as a teacher and has 2 children. Bruce lives in the cottage next to the family home. He's a playboy, spends most of his time traveling and watching sports. Charles works in the family business. Okay, John's assets. He has a family home with an annex cottage worth $200 million. The 2 titles are in his personal name. 2, he has a villa called Tidal Wave in Ocho Rios worth $300 million, which he recently purchased through a St. Lucian company called Tidal Wave Limited. Some of you may be familiar with the use of St. Lucian companies or CARICOM vehicles to own assets in Jamaica for tax reasons. 3, he owns 60% of the shares in a successful family company called Royal Car Parts Limited. 600 shares, that's 60%. The other 40% is owned by his business partner and longtime friend David. Charles is the CEO and has overseen a long period of success in the company. His 600 shares in Royal Car Parts Limited are worth anywhere between $250 and $400 million. He also has a few cars, watches, bits of jewelry, artwork worth $70 to $100 million. So all told, the total value of John's estate is $900 million, give or take. What you'll find is, valuations fluctuate between the time you do wills and estate planning and death. John's objective is to more or less share his estate equally between his children. He proposes to achieve this by giving 1, the villa called Tidal Wave to his daughter Anna. Remember, that's worth about $300 million. His 600 shares in Royal Car Parts Limited to his son Charles. That's worth, between $250 and $400 million. And the family home and personal belongings to Bruce. He prepared a short will to achieve this. John executes a valid will, so there's no issue with getting the will right or invalidity or it being challenged. The will provides as follows. I give my 100 shares in Tidal Wave Limited to my daughter Anna. I give my 600 shares in Royal Car Parts Limited to Charles. I give the remainder of my estate of whatsoever nature and wheresoever situated to my son Bruce. So what he has done is he has given the villa worth $300 million to his daughter, the company business shares to his son, worth $250 to $400 million, and he's just given everything else, which adds up to maybe $250 or $300 million, to his son Bruce. Here's a multiple choice question for everybody. What happens on John's death? What is the legal result? Is it A, per the will, Anna gets the villa, Bruce inherits the family home and personal belongings, and Charles inherits the shares in the family business? Or 2, has Charles been able to finagle everything, Has Anna been able to get everything? Has Bruce been able to get everything? Or is there some hybrid situation not consistent with the will and his instructions? Here is the answer. Bruce inherits everything. This is fantastic news, by the way. I'm just letting you know. I just want you to know. But let us look at why. Let's start with Anna. The shares in Tidal Wave Limited. In accordance with common practice, as I mentioned before, John set up a company in St. Lucia to purchase Villa Tidal Wave. Setting up a company tends to be an administrative process done through lawyers or corporate agents, which involves, or in this case resulted in John completing a few forms, providing copies of his passport, paying the administrative fees, and being issued with a share certificate for 100 shares. Usually it's 1 share, 100 shares, 1,000 shares, but that tends to be the sort of norm for setting it up. So, John validly gives these shares to Anna. No issue. Anna's got the shares. And remember, John is very smart. He gave the shares because the company owns the villa. What's the problem? Here's the problem. John funded the purchase from his personal funds. The company was set up with $100, so it has no money. The monies used to fund the purchase came from John. The structure of this transaction, namely John using his personal funds to buy a property and put the property into a company, has to be accounted for in the financial statements of the company. This will give some insight into the problem. The correct accounting for this transaction in the balance sheet of the company is a shareholder loan, where John has loaned $300 million to the company. Let's look at the balance sheet. Very simple balance sheet. Sorry for those who don't have any accounting experience. But here's what the balance sheet looks like in its simplest form. The assets, one property called Tidal Wave Villa, which is worth $300 million. Liabilities are a shareholder loan to John, $300 million. Equity, assets minus liabilities, $0. Obviously, I've left out the $100 that was used to set up the company, and I've left out the costs, annual costs of maintaining the company. The point, therefore, though, is that this company is pretty much worth $0. Simply put, there's no equity or value in the company. Tidal Wave owns the villa, but owes John $300 million. Unfortunately, this $300 million debt owed by the company to John becomes an asset of his estate, which passes to Bruce, because John's wills provide that Bruce inherits the residue of his estate. Tidal Wave will likely be forced to sell the villa to pay the $300 million to Bruce, but frankly, that's unlucky for Anna, because it looks like Bruce has inherited that money. Good news number 1. Charles, the 600 shares in Royal Car Parts Limited. I guess the starting point for this consideration is that the transfer of shares in a private company will always be regulated by the company's articles of association or any existing shareholders or partnership agreement existing between shareholders. In this case, when John and David set up Royal Car Parts Limited, they agreed to a standard provision in the Articles of Association, which provides that upon the death of either shareholder, the shares of the deceased shareholder must first be offered to the other shareholder. So Charles is required to offer on his death to offer the shares to David. If David had died first, then his shares would have had to be offered to John. David decides to buy John's 600 shares, so pays the valuation price. Let's say that the shares got valued for $250 million to John's estate in exchange for the shares. Who gets the money from the share sale? This raises a legal question as to whether Charles is entitled to inherit the $250 million paid for the shares by David. Surely it would be unfair for him not to receive the sale proceeds. Perhaps But the answer lies in the complex body of law applicable to specific gifts where the subject matter of the gift cannot pass under the will. Consider the following specific gifts, and these were actually taken out of 2 wills that I've seen. I give my silver Prado, 2020 Prado, license number X to my daughter Joanna. Versus I give my silver Prado to my daughter Joanna. If I no longer own this car at the date of my death, I give any replacement car which I own to my daughter Joanna. What happens here? The first gift fails if the Prado has been sold and upgraded to a newer model, whereas in the second scenario, Joanna will inherit the upgraded vehicle. The key point here, though, is in the first scenario, the replacement Prado falls into the residue. There are strict rules dealing with specific bequests, which can result in gifts lapsing or failing. The legal term is adeemed, if the asset no longer exists or cannot be lawfully transferred. So, the consequence of John's passing and his inheritance is that we have one big happy family. Since the will provides that Bruce inherits the residue, he will inherit the family home and all of the chattels and personal belongings. Seemingly, however, he will also inherit the $300 million used to fund the Villa tidal wave and the $250 million sale proceeds from the sale of the 600 shares in Royal Car Parts Limited by David. Fortunately, John will never know. It's not his problem now. I don't know if anyone has any questions on this. I mean, there is a time at the end for questions. I presume nobody has any objections to Bruce inheriting everything. All right. Okay, so stating the obvious, the purpose behind this example is to highlight the complexities and risks associated with estate planning for an apparently simple estate. These sort of potentially unfair results can be avoided through careful will drafting. When I prepared this presentation, I actually contemplated explaining what could be done to avoid these pitfalls. But it occurs to me it might be easier to do that now. If, with respect to Anna's going back, with respect to the legacy to Anna, if the will had provided that he gives the shares in Tidal Waves Limited and the debt owed to Anna by the company, if that was what the specific bequest said, then there would be no problem. I rarely see wills drafted which address this particular situation. Charles. What should have happened with Charles is, well, the truth is, on review and doing his estate planning, the hope would have been to try and negotiate with Charles and David to have the Articles of Association provide for the shares being able to pass via inheritance to their children. Sometimes people don't want it, but to protect against the wrongful inheritance or Charles losing it, the legacy should have said, or the proceeds of sale of the shares. If it had been specific, there would have been no risk. What the law actually says is, if the subject matter of the gift doesn't exist at the time, or it cannot lawfully be transferred, I'm paraphrasing, unless there is a contrary intention in the will, the gift will effectively lapse. So what you want is for the will or the testamentary document to make it clear that in the event that the gift cannot be achieved, then the proceeds of sale or whatever else goes to the same legatee. Okay. Moving on to section 2, why do we need a will? Well, I think the basic premise is that wills allow you to decide how your assets are to be distributed, and it is a simpler and faster process. If you don't leave a will, or you leave, or aspects of your will are not covered by a will, you'll end up with an intestacy situation or a partial intestacy situation. What an intestacy situation arises where you die without a will, in which case the Intestate's Estate and Property Charges Act will apply. This sets out how the assets of the estate are to be divided among your next of kin. This is an abridged summary of the table of distribution. Not quite sure. Okay, that's a typo. That should say intestacy, not insolvency. This is not comprehensive because I didn't think it was appropriate to be, but the starting point is that the surviving spouse receives the personal chattels, 10,000 Jamaican dollars, and a percentage of the estate, depending on whether there are surviving children or parents. If there's no parent and one child, I believe the surviving spouse inherits 2/3, but if there are 2 children, I think it's 50%. If there's no surviving spouse, then the children will inherit equally. If there are no children, or their children, if the children have died during the testator's lifetime, leaving children, then those children will inherit. If not, it goes to the parents and on. So if not, it then goes to the siblings or half-siblings or their children, grandparents, aunts, uncles. And if there are none of these, it goes to the crown, called bona vacantia. You definitely don't want that. Better you leave it to your lawyers. Okay, so pulling it all together, it provides an arbitrary distribution of the assets. It does not take into account the particular financial circumstances of your next of kin or the nature of your relationship with a particular relative or people who are not related. And it's a much longer and more complicated process. I decided to put together what I would summarize as the basic considerations in preparing a will. I guess the most important consideration is that it must be executed in accordance with certain statutory formalities. The principal one is that it needs to be executed in the presence of 2 witnesses. It's advisable to have an attorney to prepare this, especially with a complicated estate, but in my view, in any event, if there are minors or situations where you have contingent situations, such as if somebody passes or you're creating trusts, you definitely need to have an attorney. My own view is that you should have an attorney draw up your will in any event, but others disagree. Very important to appoint executors under the will. Executors, their power on death, the power to take action vests in the executors. If you don't have any executors or an intestacy, you have to wait until you have gone down the process and administrators have been appointed for them to take action. It's advisable to appoint more than one executor because certain laws require 2 parties to execute land and stuff like that. You should also have, in my view anyway, a decision-making mechanism between executors because you don't want a stalemate. This, I would suggest, is either be having an odd number, but I have seen provisions where someone says the older of the 2 or the younger of the 2 or something along those sorts of lines, just so that in the event there is a stalemate, it's not deadlocked on particular issues. I personally like an odd number. All right, residuary clause. This is very important. In fact, if we go back to the example, well, you need to have a residuary clause because it's a sort of mop-up clause. It picks up everything that's owned by the testator. And if you don't have it, a partial intestacy situation will be created. But what happened in the example before is that, can you all hear? Okay. The mechanism was used to identify assets and give them to particular beneficiaries, Anna and Charles, and then just giving the residue, the remainder, the what left, to Bruce. What you need to appreciate is that if gifts fail, they fall into the residue, which basically means that if you are not clear on the validity of specific gifts, you run the risk of them falling into the legacy and ending up into the hands of a beneficiary that perhaps you didn't intend to benefit. Marriage revokes a will. Divorce doesn't. You can choose how to dispose of your body. It's important to some people, not to others. You are able to appoint guardians over minors or young children. There are also special rules regarding what's called revocation of wills, destroying them. I don't know, for those of you who have seen wills before or have done one, you will tend to see the opening line in a will, I hereby revoke all other wills and testamentary dispositions, or something along those sorts of lines. The purpose of that is to say that that will has now been replaced. There are some complicated rules with regards to revoking wills. For instance, some people rip them up and they destroy them. That would revoke them. But there are also situations where parts of wills are damaged or have been ripped up or crossed out, and they're very complicated rules dealing with whether or not the will has in fact been revoked. So that's an area people need to be careful with. Choice of witnesses, again, attorneys should advise you of this. But it's actually very ironic, because when I was doing this presentation, so the point here is that our laws used to provide that witnesses, beneficiaries who were witnesses, the gift would fail if a beneficiary witnessed the will. The law changed in, I think it's 2015, to provide that the gift can be valid as long as the beneficiary follows a particular process. But it's ironic, because I was finishing this presentation on Friday, and one of our employees, a driver, actually walked into my office and he said, "Mr. Levy, I have a question for you. In my mother's will, a beneficiary of a property witnessed the will. Is it valid?" It was just apropos to me, because as I was doing it, he asked the question. And the law has changed, and I believe the law, I couldn't give him a direct answer because I didn't know the date of the will. And I think the changes came into place in 2015. So after 2015, a beneficiary can witness the will, but he still has to follow a particular process to do so. Okay. Taxes, duties payable on death. There's a lot of good news here. And for those of you who don't know, my father is also a lawyer, and it amuses him every time he talks about this, because he says there's no better time to die than now, because duties and taxes, death duties, have gone down dramatically. I'm still going to go over them very quickly. Stamp duty is really no longer material. I have set out the amounts of stamp duties that are payable on an estate, but contextually, they are immaterial, because the maximum amount is $25,000. It was previously several percent, which, when added to the transfer tax, was considerable. The duties levied on the documents that have to be filed in the court. Transfer tax is now payable at the rate of 1.5% on the following properties: real estate, leases, stocks and shares. If you don't pay the tax within a year, interest at 6% begins to accrue. The transfer tax has to be paid before any of the assets can be distributed by the executors. There is an exemption for the family home, and you can only have one family home. And recent changes in the law exempt the first, I think it's $10 million from transfer tax. But so the net, frankly, estate duties are now, I would say, in the region of 1.5%, together with whatever professional costs may be associated. We found in recent times that we have been asked to do a cost comparison between lifetime transfers and transfers consequent upon death. So that's what this slide reflects. You'll see that transfer tax during the lifetime is 2%. Legal fees, those can vary, but I put in 2% as somewhat of an industry norm. On death, you will see that the transfer tax is 1.5%. The probate fees, which really are more like legal fees and the costs associated with probating the estate, to be 3.5%. I put in executors' commission there because at least theoretically, executors are charged 6% on executing their duties in probating an estate. That could be a consideration in doing the comparison. So what the comparison shows is that it's slightly cheaper to do a lifetime transfer rather than doing it upon death. Okay, so here are some practical and general considerations in doing your estate planning. This is often overlooked, but executors will need some amount of readily available cash to commence the process. Note that bank accounts in your sole name or insurance policies with your estate being the designated beneficiary, they don't help you on this front because they fall into your estate, and executors need to have obtained the grant of probate before accessing these funds. Joint bank accounts. The starting premise for joint accounts is that funds automatically pass to the survivor. I have to say that my experience with banks and financial institutions as well, particularly abroad, is that they're becoming reluctant to allow withdrawals without a grant of probate, notwithstanding it is obvious that the rule of survivorship was intended to apply. It's the case more and more in the UK when I deal with a few situations where the bank simply says, no, we need to see a grant of probate. A practical consideration from this, which I tell clients or family, is consider online access to the bank account for particular beneficiaries so that you can start to access the monies before the bank actually realizes that the testator has passed. So again, if you either give it before, but if that's dangerous, you want to have somewhere where it's in your testamentary documents how to gain online access. A few points about executors and the role. They are fiduciaries, which mean they have legal and ethical responsibilities. They're required to follow the law. They cannot do what they think is morally right. It carries personal liability exposure. But I have actually had this question many, many times from clients. And if I go back to the example that we had at the outset, they're like, well, I want to give it to Anna or Charles because that's what I know, that's what he wanted, and that's what's right. Well, you're breaking the law if you do it, and it carries personal liability exposure. The reality is that if nobody objects and nobody brings any actions, then perhaps it could stand. But the simple fact is that you will be personally liable if you do not follow what the law says. Executors can, in certain circumstances, charge 6% of the value of the estate. I say in certain circumstances because the law seems to me to be a little bit convoluted as to whether or not it applies to all situations, but I would say that the industry norm is that executors charge 6% of the total value of the estate. That should be borne in mind in the choice of executors. The principal duty is to ensure that the estate is distributed in accordance with the wishes of the deceased as set out in the will. This role typically involves identifying beneficiaries, ascertaining and valuing assets, dealing with debts and claims, preparing an estate account, etc. So it's a fairly serious job which I need to understand. I contemplated putting in what I describe as a complicated situation, but it arises with some frequency, and that's where the will has left a life interest to somebody, or put another way, they've said the income from the estate goes to a particular beneficiary, often the spouse, but it could say that person is entitled to the income from the estate. That creates a situation for the executors to consider, because he then has to look at all of the assets to make sure that is he maximizing his duties as it relates to the person entitled to the income. Suppose the estate consists of a large boat, a number of assets which have no income earning capacity. Are his obligations to sell any of these assets or turn them into income generating assets? There's a fairly complex body of law which deals with obligations in relation to investments, etc., which you should discuss with, which all executors should discuss with their attorneys at the time. And I've said before, the number of executors. I think this is a very important decision, especially with large estates. One of the things executors don't realize, well, when you agree to be an executor, you don't realize you may have a lot of grumbling and miserable beneficiaries. There's going to be conflict because most people, well, often some beneficiaries are dissatisfied with the results of the decisions of the testator. Okay. I now come along to what I would describe as common pitfalls I see in the estate planning process. I wouldn't say this is a number one, but I think that this is one that creates the most problems. The use of international business companies or offshore company structures to own Jamaican assets without taking comprehensive professional advice or understanding the implications. By way of simple observation, the shares in these companies are foreign assets governed by different laws and procedures. It's perhaps odd not to seek professional advice from the jurisdiction in which the asset is located. And more, as it relates to St. Lucia or Belize or a lot of these areas where CARICOM vehicles are used, advice is not sought from lawyers in those countries. Another situation that arises, which people don't realize, is that there's a duplicate probating process that has to take place if you have shares in a overseas company which you have bequeathed to a beneficiary, be it your children or otherwise. You will typically need to probate the will in Jamaica and then go through what's called a resealing process in the jurisdiction that the company is located. If St. Lucia is the one, then you will need to reseal the grant of probate or follow whatever the requisite procedure is in that country. So already have a duplicate process. Another main area of problems I see is the gifting of shares in limited companies or corporate vehicles. Broken down, here's where I see the problems lie. The failure to appreciate restrictions which affect the transferability of shares and may nullify or affect the gift. That was highlighted in the example to Charles. There's another problem I see, and it's very common actually, and that's a failure to appreciate that bequeathing shares in a company is different from giving assets owned by the company. We Jamaicans tend to be quite informal in the way we, make our arrangements. And typically, I see people say, I'm giving that house or that property or several properties to different people when the property is actually owned by a company. So they haven't addressed the shares owned by the company. They've simply just said, I leave that property to a particular beneficiary. there are risks that gift could fail, but it's extremely problematic to resolve even if the gift itself does not fail. And I guess the third one is a bit bigger picture, but I came across this twice perhaps, where there's a failure to appreciate succession planning issues in family businesses where shares follow a particular path and they end up giving control or removing control from a particular intended shareholder in relation to the business. So the truth is that is a very complex area, and due consideration should be given. I mean, the wills are not a shortcut for succession planning. I've seen people think it is. The truth is, it definitely is not. The same level of thought and consideration, perhaps more, needs to go into succession planning issues for family businesses as part of the estate planning exercise. This is a bit of a repeat of one, but failure to take legal advice for foreign assets in conjunction with local advice. Here's an example, and again, this is rather ironic. Some people do separate wills for different jurisdictions. Now, if we go back to looking at a typical will, within the first few lines, it says, I hereby revoke all wills and testamentary dispositions. So if you go ahead and prepare different wills for different jurisdictions, which you can prepare wills limited to your assets in a particular jurisdiction. That is fairly common. But if both of them contain a provision which says, I hereby revoke all wills and testamentary dispositions, the later will is going to revoke the earlier will, and that's going to create major problems. Another irony is that yesterday I was working on this, and a partner in my office encountered the exact same situation where somebody did two wills in different jurisdictions today and yesterday, clearly intending one to apply to Jamaica and the other one to apply to Florida. The Florida one was done separately. So for all intents and purposes, it looks like the first will may end up being revoked. There are other considerations that go into it, but the starting point is that any legal advice sought in relation to a global estate should be done in conjunction with your local professionals. It should not be done independently. Another area which comes up fairly often is, and some people may be familiar with it, often your lawyers discuss it with you when you're buying a property, and it's a distinction between owning as joint tenants or as tenants in common. Those are the legal terminologies. What really it means is that, the people who own it, are they owning it? Does the rule of survivorship apply? In which case, as somebody dies, their interest passes automatically to the other person? Or is it that the interests are divisible so that when one dies, they can pass their share of that asset on to whoever they wish? Most common, I would say, with real estate ownership in Jamaica, people often own properties as joint tenants with their spouse. What I would say is that, and I have done this a few times, is if you go back to one where you are using offshore vehicles and stuff, and I said that you may have to go through a second process of reprobating, the possibility exists to own the shares in these companies as joint tenants or having the rule of survivorship apply, in which case you can pass ownership of the shares upon your death automatically. That's a consideration. Okay, I suppose this is a kind of catch-all, and it's really the object of today's presentation, and that is, in will drafting, you need to clearly state the intention regarding gifts and bequests, especially land. And I'm going to give you an example. At the moment, death duties are down to 1.5%. There's nothing, it's not important. However, these used to be up to, say, 20%. So gifts of real estate and shares used to incur 20% of death duties. Unless gifts are made subject to the payment of tax, the taxes and related costs must be paid out of the residue. This can have an unintended effect. Let me give you an example of a situation that I'm currently dealing with. Jamaican testator has a very valuable UK property. Does his will, leaves the UK property, leaves everything in accordance with his desires. Here's the problem. The UK property is subject to inheritance tax at 40% over a particular threshold. What this means is that unless he has said subject to the payment of the taxes or some similar wording, he is entitled to inherit the property free of the payment of these costs and taxes. That amount has to fall out of the residue. Now, if he had a property in the UK worth £2 million, then the long and short of it is it's about £500,000 or £600,000 is going to come out of the residue to pay this gift. Again, consideration needs to be given. If you're making a bequest, who bears the costs of it? What are your intentions? What I've noticed is that the expectation seems to be, well, actually it varies, but a lot of people assume, or the testators assume, that the costs will be borne by the beneficiary. Beneficiary doesn't think that when the time comes, but the long and short of it is that that issue should be considered by the lawyers and the will should be clear on it. If you want the costs to come out of the legacy, you need to expressly say so. All right, this is a bit of a by the by. What we've explained is that the use of wills or the intestacy process defines how a deceased estate is going to be distributed. However, the possibility exists that the estate or parts of the estate can go to somebody else in the event of a challenge by a limited group of individuals who I would describe as relatives. It applies regardless of whether or not it's a will or an intestacy. And what it basically says is that an applicant can apply to the court on the basis that the will has not made reasonable financial provision for the maintenance of a particular person. The will sets out the people who can make the application. Generally speaking, it's spouse, children, parents, common law spouse. It also sets out the relevant considerations for the court, which amongst others include the nature of the estate, the relationship with the parties, and the court has an overall power to assess the circumstances of the case. But the issue is that reasonable provision for the maintenance of a particular person. And the court can then order periodic payments or particular transfers of property, etc. Okay, I guess that's a good point to dovetail into trusts, because we commonly get questions regarding, should I set up a trust? So I was asked to give a very concise summary of really what a trust is and perhaps when it can be used. In very simple terms, a trust is a legal relationship or structure in which one party, A, gives a second party, B, the right to hold title to property or assets for a third party. A is called the settlor or grantor. That's the person who creates the trust. B is the trustee. And C is the beneficiary. Not that this really matters, but the history of trust dates back a long time. And I remember when I was a law student, the first year I did trusts, it was all very convoluted to me, but the example was given where when men, because in those days only men went off to war, they typically transferred their assets to somebody else to hold for them, because chances are they weren't coming back. The future was uncertain. Several years later, when some came back, there was a major issue with reclaiming their property. And this, at least in part, created the evolution of a court of equity or fairness to try and resolve the issues of where they had their attempts to get their property back. That's the kind of history. Okay, the roles of trust in estate planning. Simply put, it can create avenues to achieve particular objectives constrained by law. A simple example. There's a common objective for older parents to transfer family homes to their children before death. Earlier on we did a lifetime versus post-death comparison for transfer of real estate. The concern here would be that the children evict the parents or sell or mortgage the house if the property is unconditionally gifted to them. A trust mechanism can be used to transfer title to the children, but provide the parents with a right to occupy during their lifetime. That's what I would describe as a relatively simple situation. Another common use of trust is to defer an inheritance for children until a particular age. It therefore follows that trusts may be automatically created under wills, for example, if they're minor children, because minor children cannot legally own assets, so they will be held on trust until they reach the age of majority, 18. This is part of the reason why most wills contain that frustrating laundry list of complicated clauses, which really are intended to give the executors powers to take certain action which they may be restricted from under the laws that apply to trustees and fiduciaries. Another common use of trust is to ring fence or protect assets from third parties in marital situations or family companies where they don't want it to fall into other hands. As I said before, trustees are fiduciaries who are bound by strict laws. We recently passed or updated, that's actually the Trust Act, not the Trustee Act, which has updated our framework. It has introduced a concept, although it's not here, of protectors and enforcers, which are a kind of added tool to ensure either the proper enforcement of trusts or to ensure that it is properly protected and that the trustees behave as they should. A discretionary trust. I toyed with whether or not to introduce this discussion here because it's fairly complicated. But a discretionary trust is a trust relationship which gives the trustees the power of discretion, how to apply the assets within the trust for the benefit of the beneficiaries of the trust. It's sometimes used to ring fence assets or tax agility. It's a fairly complicated area, but it's the concept of this is my wording, no identifiable beneficial owner for the assets that creates this avenue for agility. Because typically a discretionary trust has a block of assets in the trust and their application is dependent on the trustee's discretion. So no one beneficiary can come along and say, I am entitled to X or Y. So this allows flexibility under some tax regimes which impose taxation obligations based on either ownership or vested rights to ownership. What I will say is that first world jurisdictions are becoming more and more advanced in the legislation they use to catch these type of situations. So I'm not sure these are as effective as perhaps they used to be. General comments, I would say they can be very useful, but are situation specific. I don't think someone should run along and say to their attorneys, I want a trust, please set one up for me. It should be more along the lines of, these are my objectives. Can they be achieved under a will? And if not, what other mechanisms or structures are available to me? And in many situations, a trust is a legitimate consideration. It follows that you require specialist advice and guidelines. There are also certain formalities that must be satisfied to set up a trust. I mean, these, I guess, are fairly obvious. The settlor must intend to set up a trust. It must be obvious what the trust assets are, and the beneficiaries must be clear and certain. Identification of trustees. A lot of people use professional trustees, depending on the size of your estate and decide and what the objectives are. They can be costly. So again, tends to be quite a comprehensive exercise, the setting up of a trust structure with professionals. Should not be done haphazard. Okay, we're nearing the end, which is good news. Point one, you've got to make a will. If you don't make a will, you're creating potential chaos for those behind you. If you don't care, then don't make a will, I suppose. Choice of executors, I think this is very, very important. You should actually speak to executors before so that they understand the role that they have. But remember, they're entitled to charge a fee. I think you should also make sure that they're able to make their decisions equally. You can make provisions to have substitute executors. Your lawyers will advise you on all of that. Get comprehensive professional advice, especially with overseas assets. Practical advice, I would say make an inventory of valuable personal assets. You'd be surprised to know how many assets disappear for whatever reason when people are unwell. You'd also be surprised, often executors and beneficiaries don't even know the assets that you owned, things like jewelry, all of that sort of stuff. It's a little bit tedious, but also if you make an inventory of all of your personal assets and also the structure of your assets before you go to your professionals, you will considerably reduce the professional costs in the exercise. One of the reasons why estate planning exercises is extremely expensive if properly done is because the attorneys have to go through an exercise of establishing the ownership structure and all of the assets before they even get into dealing with advising how they should pass. Finally, keep your will in a safe place. Destroy old wills and codicils. Personally, I once a will has been done, I also like to send a soft copy somewhere, whether to your attorneys or otherwise, because it's a good record of it being the last will. And if people are trying to locate it, believe it or not, locating wills comes up a fair number of times. People tend to die suddenly many times, and no one really knows where their wills are. Are they with the lawyers? Have lawyers changed? Are they in the safe? So having some easily accessible record as to your last will would be very beneficial to those in charge of administering your estate. And that's it.